Mr. Brown, if you can come up to the podium and Mr. Crisp on the
Yes.
camera here so that he's able to see you. Mr. Crisp, are you able to hear me okay? Mr. Crisp, are you able to hear me?
Can you hear me? Yes, sir.
Yes. Okay, great. All right. We're on the record in People versus Christopher Lee Crisp. This is case number 216235 and 216237. And if I could have counsel put your appearances on.
This is Ricky John, micro on behalf of the people.
Larry Brown on behalf of Mr. Chris.
Okay. We are set for, first of all, I should state for the record, Mr. Crisp is present by Zoom video today from a treatment facility. I believe this is set for arraignment on some probation violations. Is that correct, Mr.
That is
Brown?
correct.
Okay. Have you had a chance to speak with Mr. Crisp about
I have.
these? Okay. How does he want to proceed on this?
At this time, Your Honor, we would ask the matter be set for a hearing.
Okay, Mr. Crisp, did Mr. Brown go through all your rights with regard to the alleged violations with you in this case?
I think you went over partial of them, but not all of them. I'm not really sure.
Okay, you understand that you do have the right to have a hearing as to whether you violated your probation as alleged?
Yes, sir.
Okay, and Mr. Brown's indicating that you'd like to have the court set those for a hearing?
Yes, sir.
All right, Mr. Brown, is there a
Yes, sir.
time frame that you would like the court to have this set for a hearing?
There's not really a time frame. I don't think it needs to be any time soon, Your Honor. He is currently in Bear River Health. He's been there, I believe, for about a month. It's a 90-day program. We would like it out at least until after he can finish his program, but of course we would leave that to the court's discretion.
Okay, and have you been appointed on these files?
I have.
You have.
Wait, I'm not sure on the violations if I have yet or not. I'm quite certain I will be.
Okay. All right. Mr. DeLeo, any objection to setting this out like 90 days for hearing?
No, Your Honor, the only request we would make is the court could direct Mr. Crisp to have someone at Bear River fax our office verification. So Agent Davis, as of 5 minutes ago, still wasn't aware of, at least not verified, aware of where he was.
Okay. All right. And is there any objection?
Your Honor, Miss Danielle, I've called Miss Danielle.
Hold on one second, Mr. Crisp. Is there any objection to PR bond pending that hearing?
There is
Yes,
not,
sir.
Your Honor.
All right, Mr. Crisp, so we're going to set this for a hearing. You need to make sure that you stay in touch with Mr. Brown, your lawyer. Also, you need to provide a release to
Yes, sir.
your probation agent, to Ms. Davis, so that she can verify that you're at Bear River, okay?
It's already been done, sir.
Well,
I've called her every week since I have been here.
That's fine that you're calling her, but you need to provide a release so that she can verify with Bear River that you're there.
Yes, sir.
All right, I want you to do that within the next
Yes,
7
sir.
days.
I'll do it today.
Okay, very good. All right, Mr. Brown, anything further today?
No, Your Honor. Thank you.
Mr. DeLeo?
No, thank you, Your Honor.
Mr. Crisp, do you have any questions at all?
No, sir.
Okay, thank you. That's all for today, and the court's going to disconnect at this time.
Thank you.
Okay, People versus Kevin Reno, case number 236631.
The record, Your Honor, my phone, people.
Third round on behalf of Mr. Reno.
Mr. Reno, if you can come forward right up to the podium here, please. The record should reflect that Mr. Reno is present here in the courtroom today. I'd like to have counsel put your appearances on.
Just did, Judge.
Oh, I'm sorry. This is the date and time set for sentencing in this matter. Mr. Reno, have you had a chance to go through the pre-sentence report and speak to Mr. Brown about that?
Yes, sir.
All right, Mr. Brown, I did receive some medical records as well as counseling records. I had a chance to review those prior to the hearing today. Are there any other additions, deletions, or corrections that need to be made to the report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
It's either an addition or a comment for sentencing. It's just that as this is a drinking and driving case and blood was drawn, there should be a $200 blood draw reimbursement for the Otsego County Sheriff's Department.
Okay, thank you. All right, any other corrections?
No corrections or as to the body of the report, nor challenges as to sentencing guidelines for.
All right, thank you. There is a property offense here. Do you have any victims that wish to address the court today?
We do not, Judge.
Okay, anything on behalf of the people for allocation?
This is a third felony. The defendant was quite frankly violent with police officers. He threatened them and then actually had to be physically secured in order to obtain blood tests. Now, while I understand when people are intoxicated or under the influence of substances, they may act differently than they normally do. However, that's no excuse to act as Mr. Reno did in this case. Police officers have a tough enough job out there without people trying to fight them. We have a circumstance where there's 30 days jail with credit for 3 days on the drunk driving. I think that should be at a minimum scenario. Other than that, Judge, I have no additional comments. Thank you.
Mr. Brown, anything on behalf of Mr. Reno?
Your Honor, Mr. Reno did suffer through some things as a child, some abuse by his father, which surely affected him. And notwithstanding, he also was involved in an accident in 2007, suffered a tremendous amount of injury and eventually got hooked on opiates and things like that. He also suffers from mental and psychological disorders, which he is getting treatment for. This happened back in July. To my knowledge, he's had no violations. He does have steady employment. He has support in the community. He is maintaining a relationship with his children. Those are all very, very positive things for him. And again, not to try to minimize or downplay the offense here. He was clearly going through some sort of a mental episode. He dealt with it in the wrong way, but he is clearly getting some help for that right now. So I would ask court to take those things into consideration. The last thing that I really want to see for him is the progress that he's making just kind of slide backwards or be inhibited.
All right, thank you. Mr. Reno, anything you wanted to say today?
Yes, Your Honor. I wanted to apologize to the courts just for such an idiotic behavior. And during the episode, I was in a manic episode, come to find out. And through the process since getting in trouble, I've been to a mental health facility and a partial hospitalization program, which dug deeper into my psychology. And I've been diagnosed with bipolar 1, I believe schizophrenic, depression, and anxiety. And as crazy as it sounds, I'm glad that I got in trouble to address the mental health, because now I know that I have co-occurring disorders, and I just was never really aware of it. I've been substituting my whole life since a child, and then breaking my back. Obviously, I've been substituting my mental illness with substances to mask it. And since getting in trouble and going the right channels and taking the right steps to do better myself, I realized that I got dual diagnosis, and it's not only just an addiction to the substances, I also have mental illness, which I'm glad I met at the forefront, and I'm trying to take advantage of all the help that has been given to me and just trying to move forward with this.
All right, thank you. I did have a chance to review the report. Certainly your behavior during this instance is concerning. Put yourself at danger, you put everybody else in the community at danger. You're operating the vehicle in the manner that you were and in the condition that you were in. I'm satisfied based on the records that I reviewed that you have legitimate mental health issues that need to be treated and need to be addressed. And what you're telling me is an unusual thing. Many times people with mental health issues use substances as a way of dealing with that, as opposed to getting proper treatment and medications that are going to help you and not make things worse, as opposed to self-medicating and contributing and piling on to what's already a mental health problem. And the substances that you're using are going to do that. They are not good for somebody who's already starting out on the wrong foot. So I'm again satisfied that was a major component here. The question is, how do we deal with this going forward? Because what I don't want is you out in the public engaging in this kind of behavior and somebody getting injured based on what you're doing if you're not following through with your treatment. On the other hand, I don't think putting you in jail or prison is going to keep the community safer in the long run, because that's not going to get you the treatment that's going to help you avoid this from going forward. So in my view, the sentence here needs to be focused on rehabilitation, and give you an opportunity to continue with the treatment that you're following right now. And the records that I got indicated that you've been participating in a lot of counseling sessions. The last record I got confirmed that you had 24 counseling sessions under your belt. You've sought medical treatment in terms of hospitalization to deal with this. All of those are good things. All of those are things that indicate to me that you're taking this seriously and that you're going to try to prevent this from happening again. And so I think we're all better off in the long run if you continue to do that. So I'm going to fashion a sentence that allows you to continue with that, but that also provides that if at some point you're not doing that, that we're going to take you out of the community so that you're not out there and presenting a danger to innocent people who don't have anything to do with you or your issues. So you're going to have an opportunity to continue on the road that you're on. To the extent that you don't, there's going to be a significant penalty on the other side of that. Not only, number one, to hopefully provide you with motivation to continue doing what you're doing, but number two, to provide a consequence and to, again, provide the safety of the community by having you incarcerated where you can't present a danger. So as to counts 3 and 5, the court is going to, and this is not something that's recommended, so Mr. DeLeo, the court's just going to ask that we impose standard terms and conditions for probation. But the court is going to place you on probation for a period of 24 months. The court is going to adopt as the conditions of that probation all standard terms and conditions. The court is going to make as a condition of that probation that you continue to participate in and successfully complete any mental health or substance abuse counseling or treatment that's recommended to you, that you not use or possess any controlled substances unless they're prescribed to you, that you not use or possess any alcoholic or other intoxicating substances. The court is going to place you on probation again for a period of 24 months. The court is going to order that if you serve 9 months in the Otsego County Jail and you do have credit for 3 months served, the court is going to hold that time in advance to be served at the discretion of the court. So if you do violate your probation, the court can impose any or all of that jail time immediately, without any hearings, nothing, just do not pass go, straight to jail.
Okay.
And that's in addition to any penalties that you might face for violating your probation, which your guidelines call for up to 21 months. So if you violate your probation, you could even be sentenced to prison and still be within the guidelines.
Yeah.
So there is a significant penalty if you don't follow through with the probation. Court is going to order $130 in a crime victims assessment, court costs of $325, attorney fees of $350, DNA testing fee of $60, and $100 state costs. Again, that's as to counts 3 and 5, as well as a $200 reimbursement for the testing as indicated by Mr. Rolla. As to count 4, unlawful use of a motor vehicle, a $68 state cost, 30 days in the Otsego County Jail with credit for 3 days served, that time also held in advance. You do have the ability to seek an appeal of this sentence. Mr. Brown's going to provide you with an acknowledgement of those appellate rights.
He has acknowledged that, Your Honor, and I am tendering that to the court.
And then Mr. DeLeo, Mr. Brunical, be the supervising agent.
He will, Your Honor. He'll get a hold of Mr. Reno.
Okay, so Mr. Brunical that you've met with for the pre-sentence report, he's going to be in touch with you. It's important that you follow up with that contact. And again, I can't stress to you enough, Serena, how important it is for you to follow through with your probation and with your treatment, because at this point, that's really the only thing that's going to keep you out of jail or prison. Mr. Brown, anything further?
No, Your Honor, thank you.
Mr. Rolla?
No, Your Honor, thank you.
Right, that's all for today, Mr. Reno. People versus Eric Splan, case number 236635.
Rick Turner, Rollback People.
Larry Brown on behalf of Mr. Splan.
Is Mr. Splan present? Yeah. You can come forward to the podium, please. Record should reflect Mr. Splan's present here in court today. This is set for a status conference. Mr. Brown, can you tell me where things are at with this file today?
Yes, Your Honor, I had conversations with Mr. Splan as well as negotiations with the prosecutor. There has been a plea offer in this matter to plead to count 1 as a habitual second offender. And the other enhancements would be dismissed. This is, of course, if he's on parole, then it's going to have to run consecutive to any parole violation.
Okay, Mr. Rolla.
That's correct. He was on parole at the time of the sentence.
Okay, so count 1 as a second habitual offender, the drug double being dismissed.
As well as the habitual 4th, yes, Judge.
Okay. All right, Mr. Splan, have you had a chance to speak with Mr. Brown about this plea agreement?
Yes, sir.
All right, and what we've discussed here today on the record is that the plea agreement that you discussed with him.
Yes, sir.
Okay, is that how you want to proceed today?
Yes, sir.
You raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Over your hand. Mr. Splan, you were on parole at the time that this offense occurred?
Yes, sir.
Okay, so you understand that you would not be entitled to any jail credit on this charge, and that any sentence in this case would have to be made consecutive to anything you would face with your parole violation.
Yes, sir.
Also, by pleading guilty to possession of methamphetamine as a second habitual offender, the maximum possible penalty you could face would be up to 15 years. You understand that?
Yes, sir.
With all of those things in mind, what is your plea to that charge today?
Yes.
Right now, you have certain rights. I'm going to go through those with you.
Yes, sir.
You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you. and the right to testify to trial yourself if you want it. You understand all those rights.
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir. Excuse me.
Also, you don't have an automatic right to appeal the plea that you're making here today.
Yes, sir.
If you wanted to try to do that, you would have to ask the Court of Appeals to hear your case. They could say no, and that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No, sir.
Has anyone promised you anything other than what we said here today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
This happened on September 29th of 2023. Is that the correct date?
Yes, sir.
On that date, were you present here in Otsego County?
Yes, sir.
While you were here in Otsego County, did you have possession of some methamphetamine?
Yes, sir, I did.
Did you know that that's what that was?
Yes, sir, I did.
Did you have any legal right to have any amount of that at that time?
No, sir, I did not.
Had you previously been convicted of?
Yes, sir, I did.
I just need to establish your case. That's okay. Had you previously been convicted of delivery or manufacture of methamphetamine back in 2021 here in the 46th Circuit?
Yes, sir, I did.
Mr. Rolla, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Brown?
Satisfied with the factual basis as well as the court complying with statute and court rule for the taking of pleas. I'm also unaware of any promises, threats, or inducements that have not been placed on the record.
And the prosecution would agree with the last two as well.
Thank you. Mr. Splain, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept the guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Before you leave today, you're going to meet with Mr. DeLeo from probation to set up a pre-sentence interview. And then between now and that sentencing date, it's important that you stay in touch with Mr. Brown, your lawyer. Thank you.
Thank you, sir.
People versus Eric Garrison. Garrison, come right up to the podium, please. We have two files set for hearing today, 236650 and 666551. The record should reflect Mr. Garrison present here in the courtroom. Counsel, please put your appearances on.
The record, Your Honor, my friends and people.
Larry Brown on behalf of Mr. Garrison.
Mr. Brown, can you tell me where we're at with these two files, please?
Yes, Your Honor. This is a relatively new file. I believe this is our first appearance in circuit court. It's a very document intensive file as well. I would ask the court for a 30-day adjournment. It is my belief that at that time, we get a clear direction.
Mr. Rolla?
Well, no objection, Judge. It is relatively new file before the court. There is a plea offer that's involved in this case. There is, however, a significant amount of restitution. I think that's what Mr. Brown is trying to work out with his client.
Right, just looking at the nature of the charges here, I think it's reasonable for the defense to request an additional time. And so I don't have any objection to that. Mr. Garrison, have you talked to Mr. Brown about that?
Yes, I have, Your Honor.
Do you have any objection to that?
No, sir.
Okay. The court will set this for a status conference, plea hearing at the court's next date in about 30 days. We'll go from there. Mr. Garrison, do you have any questions about that? Mr. Roll, anything further on either of these files?
Yeah, people, thank you, Judge.
Mr. Brown?
No, Your Honor, thank you.
Okay, thank you, Mr. Garrison. That's all for today.
People versus Michael Huffman, case number 236599. Matter was set for 2 o'clock. It's now 2:03. Mr. Huffman is present in person. Anybody in the Zoom waiting room? This is case number
I'm sorry, I already said that. Mr. Brown, have you had any recent contacts with Mr. Huffman?
Yes, I have, Your Honor. I had contact with him on December 3rd, December the 6th. We had a status conference on the 6th as well, and my most recent contact was on the 27th. It was my impression he was going to be here.
All right, just looking at the file here, it looks like he failed to appear. Appeared back in November. He did appear in December. Adjourned in December. So Mr. Rowland, did people take any position on this?
No, Your Honor, the only information I would provide the court is if the court recalled we were here last time, the matter was adjourned to allow the defendant to come to our office to pay restitution in the amount of $3,253.39. So it would be paid out of before sentencing. I see no indication in the file that Mr. Huffman has done so. Perhaps he needs a little more time to do so.
All right, so the court's going to set this for a show cause status conference in 30 days. If Mr. Huffman fails to appear at that time, the court will issue a bench warrant for his arrest.
Very good, Judge. Thank you.
Anything further in this file from either counsel?
Oh, yeah.
No, Judge.
Okay, thank you. People versus Marilyn Norling for 236645. Is Ms. Norling present? Okay, you can come right up to the podium, please. Record should reflect Ms. Norling's present here in the courtroom today. If I could have counsel with your appearances on.
The registrar, my call down for people.
Very Brown, we got Ms. Norling.
How did we want to proceed today, Mr. Brown?
Your Honor, again, I think this is our first appearance here. I have been in contact with Ms. Norling. There has been a plea offer in the matter, I believe, plea to count 1 for dismissal, count 2, if I recall. And I am still discussing that with her. I would just ask for a brief adjournment. And again, I do believe that one way or another, this will have clear direction at the next time.
Mr. Rowland?
People under the objection to an adjournment, Judge. This is a relatively new case. There was a plea offer to plead to count 1, the joint several restitution of $186, along with co-defendant Otsego for dismissal of count 2.
All right, so Ms. Norling, the court's going to set this for a one more hearing. We were here, it looks like, based on my records, we were here back in December, court granted an adjournment then. I'm going to grant one more brief adjournment, but Ms. Norling, the next time we're in court, I'll need you to have made a decision about whether you want to proceed with the plea or not, okay?
Okay.
So make sure that you stay in touch with Mr. Brown so that you're ready to make that decision at that time, okay?
Absolutely.
All right, thank you. That's
Thank
it. Next one is set for 215 People versus DeMassey. That case is going to be by video. I don't see Mr. DeMassey connected yet from Department of Corrections. So we'll take a short recess and proceed at 2:15. Mr. DeMassey, are you able to hear me okay?
Yeah,
All right, thank you. We're on the record in People versus James DeMassey, case number 236605. The record should reflect Mr. DeMassey's appearing by video from the Department of Corrections. This is the date and time set for sentencing this matter. If I could have counsel for your appearance.
For the record, Your Honor, my full absent people.
Larry Braun on behalf of Mr. Demansky.
All right, Mr. Brown, did you have a chance to go through the pre-sentence report with Mr. DeMassey?
I did, Your Honor, because of the holidays. I went over it with him on the phone. Somebody did get back with me. I was able to get it to them. They were going to try to get it to Mr. Macy, the actual hard copy, but I did review this with him.
All right, Mr. DeMassey, did you have a chance to go through the pre-sentence report and discuss that with Mr. Brown?
I did, Your Honor.
Okay. Mr. Brown, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rilla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections as to the body report, nor challenges as to scoring. Thank you.
Any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocution?
Yes, Judge, this is a fourth felony, oddly enough, or not oddly enough, as the case might be, with the same type of offense, criminal sexual use of material. This time, the defendant was apparently, according to the reports, in possession of 71,552 images, 1,911 videos. This is a defendant who was proven not only by his past behavior, but now his current behavior, for which he's being sentenced before the court. And quite frankly, he's a danger to the community and children in the community when not incarcerated. Now, while I understand the argument, it says that, look, he's only maybe looking at these pictures. He's not the one making them. The fact of the matter is, the reality is, it's just like with controlled substances. If you're purchasing them, if you're obtaining them, you're actually helping the people who produce them because you're the market for them. And obviously, then that causes further exploitation of children. I'm not saying Mr. DeMassey did that even intentionally. He may have his own prurient reasons for doing so. But in any case, there's a recommendation here of 80 months to 10 years with 0 credit. And I think it's appropriate. Thank you.
Thank you. Mr. Brown, anything on behalf of Mr. DeMassey?
Your Honor, firstly, and I do know the number of images in the report. I don't know how many of them were actually of this nature. Not all of them were. He does have some strong family support outside of here. And so he does have something to look forward to, something to return to. He has been doing very well while he is currently incarcerated. He does have a job in the kitchen there. He doesn't have any misconducts to date, so he minds his own business. And he does suffer from a lot of mental health issues, which one of them is a low functioning IQ, some borderline issues, mood disorder, ADD. One of the things, and again, Mr. DeMassey believes that he may have this under control. That is something I might disagree with as far as the medication goes, but I think not feeling like you need that medication or help may be a product of some of the illness there as well. So that's kind of a catch-22 circular issue, but I think, Your Honor, this is something that incarceration, while I understand the need to protect society, in the long run and ultimately, this is not going to correct the problem or the behavior. He needs to really understand what's going on here. By all accounts, he had a normal upbringing. So there are some other issues going on that need to be explored and find out what is going on, that he can maybe get some help for it so that this doesn't happen again.
Thank you. Mr. DeMassey, anything that you wanted to say today?
Sure, Your Honor. Putting towards more of what the images are running, because I read the packet here. I do have cousins that were about the same age, and I just don't agree with some of the stuff that was said in this packet of what the descriptions were. I just think it's disgusting, but I do think I could use some counseling to get me back to where I'm at. Back on track of not being ever in the situation again.
All right, thank you. I did have a chance to read through the report, Mr. DeMasi. So I'm familiar with the allegations here, the information contained within that report. It also contains information about you and your background, your previous charges and so forth. So I've had a chance to review all of that. I've also had a chance, of course, to hear the allocution of both the lawyers and yourself here on the record today. And number one, I would say that this type of crime is one of the most serious crimes that the court deals with, because number one, it involves vulnerable individuals, children who aren't able to defend themselves and who depend on adults to take care of them and make the right decisions with regard to what happens to them. And so when this type of material is generated involving actual children, there's of course an immense amount of harm that occurs to those children as a result of this. And I completely agree with Mr. Rolla when he says that while consumers of this type of material aren't producing it, they are making it possible, they are providing a market for it, they are giving the people who do produce it a reason to do it and to continue to do it and to continue to victimize the children. And so I think the people that are involved in consuming it are every bit as culpable as the people that are producing it. To the extent that any of these images were computer generated, again, even if they didn't involve actual children, they're encouraging people to consume, to produce this type of material that does involve real children and contributes to the continued victimization. And it's a huge problem in our country and in other places throughout the world. And so the court has a very vested interest in discouraging the production and consumption of this type of material. And there's no doubt in my mind that you were consuming it. You can argue factual differences between what's in the report and try to draw some lines there, but there's no question in my mind, based on what I read, that you were very much engaged in the consumption of this type of material. That you were on parole while this was happening. You continue to engage in this conduct and to find ways to get access to it, even though you weren't supposed to have it as a result of prior cases. And that indicates to me that you do have some kind of compulsion that you're unable to control, and that supersedes any kind of court order or any kind of court imposed requirements, that you're willing to find ways around those types of court imposed things in order to get this material and to continue consuming it. And so that gives me serious concerns with regard to you personally and whether or not you would reoffend if you're released. And my feeling is, as of this point, that you absolutely would, based on your conduct in this case in relation to your prior cases. And so for that reason, the court finds that at this point, what the court needs to do for the protection of the community is to make sure that you don't have any opportunity in any way to access this material. And the way to do that is to give you a lengthy prison sentence. And I think it's warranted in this case based on your conduct. And so the court is going to follow the recommendation, which is 80 months, which is right at the limit under the Tanner 2/3 rule. So the court is going to sentence you to the Michigan Department of Corrections for a period of 80 months to 10 years. Because you were on parole at the time, you are not entitled to any jail credit, and the sentence is required to be consecutive to any sentence you would serve as a result of a parole violation. Court is also going to impose a crime victims assessment in the amount of $130, court costs of $325, attorney fees of $350, the DNA testing fee. I'm sorry, the court is not going to impose the DNA testing fee. I'm quite certain that that's already been done as part of your prior case. A $68 state cost. You do have the ability to appeal this sentence. If you haven't already received it, you will be provided with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal Mr. Valio?
Judge, just so the record is clear, Mr. Demasi was on probation at the time.
Oh,
The reason he has no credit is because he's under sentence out of Emmett County
okay.
at the time the charges arose.
I'm sorry. Thank you for that correction. I thought that it was a role status. So there is no consecutive, but there is also no jail time.
Oh,
Not-
credit.
Not right.
Okay,
No jail credit. Big sentence status. Okay.
thank you.
All right. Again, Mr. Demasi, you will be provided with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with any appeal. Mr. Regola, is there anything else we need to address for the record today? Mr. Brown.
No, Your Honor.
All right. Mr. Demasi, that's all for this hearing today. You are remanded to the custody of the state to begin serving this sentence. Great. Our next hearing is set for 2:45, People versus Ashton. The court will be in recess until that time.
Okay, we're on the record in People versus Nicole Flynn Ashton. This is case number 236543.
The record, Your Honor, might call that people.
You're Miss Ashton?
Yeah.
Okay. Miss Ashton, have you had any contact from your lawyer?
He's so hard to reach.
Okay.
It doesn't surprise me that he's not here today, to be totally honest.
All right. Are you aware that there's, I believe we have a bench warrant out for your arrest?
For my arrest,
Yeah.
I am unaware. From my last appearance,
Judge, the file notes from December 6th, I believe you're referring to. And then for failure to appear previously on November 8th, 2022.
But do we have an active bench warrant on? I don't have one.
I see
Judge,
one
my-
issued on the
Ms. Van-
7th of December.
My chief assistant,
What's
Ms. Brooker's file notes indicate that there was a request to appear by Zoom. You denied that request. She failed to appear. The court issued a bench warrant and 2 show causes for her counsel at the time.
Yeah, she failed to appear at the December 6th, and that's when the bench warrant was.
I'm gonna,
You don't have one.
I had COVID. I asked to,
hold on a second.
I'm
okay?
sorry.
It was on the 7th of December.
All right, well, I don't have one in the file, so I don't know if one was ever signed, so I'm not gonna place you under arrest today, Ms. Ashton.
I appreciate that.
But we've been adjourning this out, so let's see. We're gonna hearing on July 6th. August 9th. October 4th. We're supposed to have a hearing by Zoom. That didn't happen. November 8th. Neither you or your lawyer appeared on November 8th, so the court set it for December 6th. Neither you or your lawyer appeared on December 6th. So we set it for today. So I understand you're saying one of those times you had COVID, right?
Last month I had COVID. The time before that, I actually drove all the way here and was sitting outside when my attorney let me know that he was going to have it adjourned. And the time, I mean, like, it's been ongoing. I've already threatened to fire him numerous times. Like, obviously it's time.
Yeah, well, I mean, your lawyer keeps calling the court the morning of the hearing and saying
Right.
he's got other things going on and he can't be
Right,
here.
yeah, he's doing the same thing to me too. When I had COVID, I actually let him know, I believe it was 4 days prior to our hearing. I was diagnosed the Monday. We had court Thursday. I let him know that I had COVID and asked, would it be okay if he asked the court if I could appear by Zoom? I never got any more communication from him at all.
Well, I mean, we've got this case set for trial. The court put it on the docket.
Right.
I think the notices went out yesterday, maybe.
Okay,
So your case is going to trial.
okay,
And so you need to have a lawyer. You need to either get your lawyer going or
So-
you need to request a court appointed lawyer.
I need to request a court order because I'm paying $5,000 for this guy who's not showing up when he's supposed to.
Okay, so I'm gonna refer your case to Gary Pilo's office. And he's gonna be in contact with you. He'll get your financial information, determine whether or not you
Okay.
qualify. But I'm gonna refer this to you or to him today. So when his office contacts you, you need to follow up with that contact.
Yes,
okay?
sir.
The court is gonna set this for another hearing in 30 days. As a status conference, but again, you need to do whatever you need to do to be ready to proceed to trial as
Yes, sir.
scheduled.
Well, I've been ready for months, just so that we're clear.
Well, you haven't been here.
Would you like our
Couple
office to
months, so-
provide, the defendant with Mr. Gilo's phone number?
We'll give her.
All right, very good, because I have it if you don't.
Thank you.
The court is, I'm most likely gonna schedule a contempt hearing for your lawyer, because that's a whole separate issue. Your lawyer needs to be here when he's required by the court to be here, regardless of anything else, so that's something that the court will address separately. But the court will set this for a contempt hearing. I mean, Mr. Daly is listed as your attorney. Who is your actual attorney?
Van Lam.
Okay.
I believe that's how he's.
That's who you've been paying to be your attorney?
I paid Dally, who contracts Van Lam,
Okay.
as far as I understand.
Okay. All right, so the court's gonna set contempt hearings for both Mr. Daly and Mr. Van Land, because one of those two should have been here today. I am gonna tell you, Miss Ashton, I get that you're having problems with your lawyers. You know, everybody, I get all kinds of people calling and saying I've got COVID and I can't make it to court. So
I have documentation if you need me to provide it.
what I'm telling you is, going forward, if you're ordered to be here in person, you need to be here in person.
Yes,
I don't
sir.
want to get calls the morning of that you have strep or bronchitis or more COVID, or your
Understand.
car broke down or whatever it is. We're at the end of things. As I said, I thought we had a bench warrant today, and the only reason why you're not being taken into custody right now is because I don't have it in the file. Otherwise, you'd be arrested on the bench warrant and you sit in jail to make sure that your case goes forward. And that's what's gonna happen next time, all right? So I just want you to be abundantly clear that the next hearing date, if we get a call from you the day before, the morning of your hearing, you got some reason why you can't be here, you wanna be here by Zoom, the answer is gonna be no, and there's gonna be a bench warrant.
It won't be from me, Your Honor.
Okay, all right. Mr. Roll, anything further on this file today? I don't, without counsel here, we can't proceed.
No, Your Honor, thank you.
Okay. Do you have any questions, Ms. Ashton?
I do not.
We're gonna provide you with Mr. Gilo's
Thank you so
card.
much.
It's probably a good idea for you to get in touch with
I
his
am.
office as well. Okay, thank
Thank
you.
you.
So to clarify, there's a note in there saying that you signed it on the 7th, but we didn't receive it for final. Right.
Okay. Next hearing is set for 3 o'clock. Looks like we have Mr. Ingersoll connected. His attorney is also appearing by Zoom, so let's just all stay here for right now. Mr. Ingersoll, are you able to hear me okay?
Yes, Your Honor.
Okay, we're just waiting for your lawyer to connect and then we'll get started with your hearing. So I'm just gonna put you on hold for a couple more minutes.
Okay.
Good afternoon.
Good afternoon. Are you able to hear me okay?
I can hear you, yes.
All right, thank you. I'm bringing your client into the Zoom courtroom right now.
Thank you.
All right, we have everybody connected. We're on the record in People versus Ingersoll. This is case number 236657. The record should reflect Mr. Ingersoll's appearing today by video from Roscommon County Jail. Mr. Hallman, if you can put your appearance on the record, please.
Thank you, Your Honor. Attorney Zachary Hallman on behalf of Mr. Nigel Ingersoll appearing via Zoom technology. Nigel, could you say your name for the record?
I'm Nigel Ingersoll.
All right, thank you. Mr. Roll is here on behalf of the people in the courtroom. Mr. Hallman, this is set for a first status conference in this case today. I believe it was just found over mid-November or late November. Can you tell me where things are at from defense side?
Sure, Your Honor. I would say the most important thing that the defense is trying to address, and I was under the impression that such was going to be addressed today, was Mr. Ingersoll's arraignment on additional charges. This has been an issue now for some time. The issue is that Mr. Ingersoll is on federal supervision. That's why he's in custody right now, because these alleged charges are alleged violations of his federal custody. And so we have not been able to arraign him on the additional charges that Mr. Rolla is aware of. And when I talked briefly, and it was before the holidays, admittedly, with Miss Bruker, then we had discussed arraigning him on those charges on today's date, potentially. And I will say in our conversations with the federal judge is wondering as well why Mr. Ingersoll hasn't been arraigned on those additional charges. And the reason is we don't want to hold this up at all anymore. We're interested in challenging the charges, all of them, and taking them to jury trial. And we're unsure why those haven't been, or why my client hasn't been arraigned on those charges, because again, we can't view the plea offers properly. We can't really prepare, of course, properly. I have not seen any of the discovery, of course, with regard to the additional charges. So that's our main concern. And beyond that, the concern, we're really trying to schedule a trial as quickly as possible. My client has been incarcerated now since September.
So obviously, I mean, this is a circuit court. I don't have any jurisdiction over whatever's happening in the district court or any additional charges. So as far as I'm aware, this is all that's been found over, and this is all that I have jurisdiction of. So I'm not sure what you'd like me to do with regard to those other charges.
No, I understand, Your Honor, that you can't really do anything about those charges. I was, with Mr. Rolla being here, I was more wondering what, I guess he and I can talk after this. My apologies, Your Honor.
Okay, so how do you want, with regard to these charges, do you want the court to get these on the trial calendar then?
Yes, Your Honor, yes.
All right, Mr. Rolla, do the people need any particular period of time to be ready for trial in this case?
No, Judge, in regards to defense counsel's comments.
No, I don't want to get into that. That has nothing to do with my
very
case.
good,
You guys can argue about that on the phone later.
It's not, I was just gonna advise the court that the only other case I'm aware of, I was gonna indicate for the record, that's all.
Let's just deal with the file we have in front of us.
No, Judge, we do not.
Okay. How many days of trial do you think we'll need from your standpoint?
I would anticipate, since we're looking at 6 witnesses, maybe a day and a half, Judge.
Okay. Any objection to setting it for a 2-day jury trial?
No,
Mr. Hallman, does the defense need any particular period of time to be ready for trial in this case?
2 days does sound adequate, Your Honor.
Okay, in terms of preparation, do you want me to just get the soonest possible date, or do you need a particular period of time that you'd like to request?
At this time, I know that I would say we're ready.
Okay, so the court will set it for a 2-day jury trial at the court's next available date. Mr. Hallman, I typically set it for a final status conference on my motion day immediately preceding the trial date. So we'll set it for a final status conference at that time. If the defense has any motions that you'd like to file, pre-trial or motions in limine, they will need to be filed and set for hearing no later than the date of that final status conference.
Okay.
And then that final status conference will also act as a plea cutoff. So to the extent that there are any plea negotiations, that would be the last day to enter into a plea agreement.
Okay.
I'm not interested in taking a plea. Can we just move to trial?
Yeah, he understands, Your Honor. Sorry about that. Go ahead, Judge.
So, Mr. Hallman, any other dates that you want to request in terms of scheduling prior to trial?
No, I don't have any more requests. Does the court have any idea in terms of the dates? I have a trial in February. That's going to start February 8th. I'm not sure what. Yeah.
No, it won't be in February because that's barely a month from now. So I'm sure my trial dates in February are already scheduled. So I don't think that'll conflict.
Okay.
Mr. Rolla, any other dates I can address for your side?
no, but I would advise the court that our office will be filing another domestic violence acts notice pursuant to MCL 716-27A.
Okay. All right. So, Mr. Hallman, the court will send a pretrial order reflecting the dates that we've discussed today, as well as notices of both the trial dates as well as the final status conference to both you and to Mr. Ingersoll, as well as the prosecutor. Mr. Rolla, anything else that we need to address from your side?
And on behalf of the people, thank you.
Mr. Hallman, anything on behalf of your side today?
No, Your Honor.
Okay, thank you. That's all for this hearing today, and all sides are free to disconnect at this time. Is this Mr. Ross? Yes. His lawyer's not here yet, so we're gonna need to wait for her. Do you think we have our 3:15 ready? Okay, Mr. Jackins, are you able to hear me okay?
Yes, I can hear loud and clear, Your Honor.
Thank you. We're a little bit early, but are you ready to proceed?
Yes, Your Honor, I am.
Okay, and I should note for the record that we also have Mr. Hess connected, so we'll go on the record in People versus Hess, case number 226346. As I indicated, we have Mr. Jackins present by Zoom video. On behalf of Mr. Hess is connected. We have Mr. Rolla present here in the courtroom today. This was set for a final status conference prior to trial, and then Mr. Jackins, you have filed a motion to adjourn based on the filing of a application for leave for interlocutory appeal. I did receive your motion. I had a chance to review that. I also did receive your filings from the Court of Appeals, which you provided to my office. Was there anything that you wanted to state for the record in support of your motion today?
Yes, Your Honor. There was one matter that was not correct in there. There was an adjournment that was stipulated to prior to this, Your Honor. The motion isn't to disrespect the court on any level. There's a very important issue in this, and we would really like it to be hashed out. That really kind of hinges a lot on this case, how it would be prosecuted, and more importantly, in this circumstance, Your Honor, defended. In this circumstance, we do have a legitimate reason. There's a constitutional issue, and we're using our due diligence in this matter, and hopefully the court will grant an adjournment in this circumstance, and hopefully this matter could be resolved in between then. But we're asking the court for an adjournment based upon what we had filed just literally this morning. It's as far as I was able to get that in, Your Honor. So we're asking for an adjournment based upon that, Your Honor.
Okay, thank you. And I didn't realize it. Do we have a stipulation, Mr. Rolla?
No, we don't, Judge.
All right. Mr. Jackins, Mr. Rolla is indicating that there wasn't a stipulation. I don't know.
I believe that there was a stipulation to adjourn the trial date a while back.
That was the previous trial date, Judge.
I was referencing. I wasn't referring to this hearing, Your Honor. That might have
Oh, okay. Got it. Okay, understood. Thank you, Mr. Rolla.
Thank you, Judge. First and foremost, our office received no notice of hearing in this. The people are not waiving notice. Second, the notice was untimely filed. It was received by our office on Friday, December 28th, and provided to our office on Thursday, December 28th, and provided on Thursday afternoon. I unfortunately did not see it as I was dealing with family matters downstate, as my father passed away that afternoon. So I didn't get to see it, and I was out of the office at that time. The defendant claims he's going to suffer prejudice in his motion to adjournment. However, he gives no facts and basis nor legal authority for his position. As to the latter, where a defendant cites no legal authority for his position, his argument for appellate purposes is deemed abandoned. It's been long held by our appellate courts. People versus Petrie, 279 Michigan Appeals, 407, 2008 case. People versus Payne, Payne, 285 Michigan Appeals, 185, 2009 case. People versus Fowler, FOW, LER, 193 Michigan Appeals, 356, 1992 case. Additionally, this court's already ruled on this motion. Our office, in fact, received a copy of the court's order following our hearing on December 13th that was signed on January 2nd. Mere allegations of prejudice are insufficient to establish the defendant's burden for a motion to adjourn. While the people would agree that some delays in the defendant's case were attributable to COVID-19, after the defendant was arraigned back on May 6, 2022, the majority of the delays, as previously found by the court, have been attributed to the defendant. If this court were to adopt the defendant's proffered position, it would simply allow any defendant to keep filing indefinite delays for leave to appeal and completely avoid trial. Again, this motion shouldn't even have been filed, although it's titled first motion to adjourn or adjourn trial. It's not his first motion. We already had a hearing on this back on December 13th. But in any case, it should have been entitled perhaps maybe a motion for reconsideration, so it's mistitled. Additionally, the defendant's request is adjournment of his January 11, 2023 trial. I don't believe he has a trial for January 11, 2023, Judge. I believe his trial is scheduled in January of 2024. Now, that may just be a typo, but it's poorly executed and set forth as the rest of the motion, all of which should be denied by this court. It is an issue, I would remind this court, that was brought up in the case of People versus Matthew. That's currently before the Court of Appeals. I anticipated a denial of their application for leave to appeal being received shortly by this court for the very same reasons which I've just indicated.
All right, thank you. Mr. Jackins, did you want to respond? You're muted, Mr. Jackins. I'm sorry.
Sorry, I didn't want the court to have any background noise. Your Honor, I did actually give notice to the prosecutor's office a while back, like literally, I think the day that I had received notice to presentment under the 7-day rule by Mr. Rolla's office. I did have an amended notice of hearing that was filed, and then I, kind of had to do some of the things in piecemeal because I couldn't quite get this filed until this morning, Your Honor. And I appreciate the case law that Mr. Rolla has brought to the court's attention. This is not a frivolous appeal. And yes, there was a typo in there. There is not a jury trial that's on the 11th. That would be on the 17th. We're about 2 weeks out, Your Honor. So we're asking the court to grant our motion for the reasons that were stated. And that's all I have, Your Honor.
All right, thank you. I did have a chance to review the motion prior to the hearing today. I also had a chance to go through the file just to kind of familiarize myself again with the track that, that this case is taken. Couple things I would say. First of all, I've had these kind of motions before, motions to adjourn on behalf of both the people, not necessarily in this county, or this particular prosecutor, but on both sides, from the defense and the prosecution, late motions to adjourn for various reasons, pending appeals being one of those. And the court's been reversed on almost all of those where I've denied the motion to adjourn. So consequently, I'm much more cautious at denying motions to adjourn jury trials in criminal cases for either side. I've found, based on what the Court of Appeals, the feedback I've gotten in those cases, and in researching this issue, that number one, the court has to find good cause. The filing of an interlocutory appeal would be good cause. The court also has to look at the history of the case, the number of adjournments, whether or not the appeal is being filed for the purpose of merely delaying the matter further. And so I've looked at all of those things in this case, and I do want to state for the record that, and I'm not directing this at Mr. Jockins necessarily, but I do believe the defendant, Mr. Hess, is trying to delay this case as long as possible. He switched attorneys in the middle of this. We had a request for a competency exam, which I granted out of an abundance of caution, but I'm not sure there was ever any real question about whether Mr. Hess is competent or not, or criminally responsible. But again, out of abundance of caution, the court allowed that process to play out to avoid any appealable issues going forward. But I do, in the motion having been filed when it was, and the information requested, again, I think I look at this just as a practical matter, and realistically, I do think Mr. Hess is trying to delay things. However, I don't think I can make a strong enough record based on what has actually happened in this case to establish that to the point that it would survive appellate review, or that the Court of Appeals on a motion to stay following this motion wouldn't grant it, because I just don't think the court has enough to be able to articulate a basis for actually finding a dilatory motive here. Even though I think, again, just realistically, I think that's what Mr. Hess is trying to do. So I say that to say that what I think is most likely to happen if the court were to deny this motion is, A, the Court of Appeals would grant it at the Court of Appeals level, and we'd end up staying the action anyway. Or B, we would go forward with the trial and run the risk of an adverse ruling for the prosecution at the Court of Appeals level, or some type of ruling that calls into question the validity of the trial, in which case we'd have to retry the case all over again. So all of that being said, and the fact that Mr. Jockins' firm, I think, has, they've actively prosecuted this case. I don't think, again, that there's been a dilatory motive on the part of counsel, and I'm attributing that to his client, not to him. All of that, I think, leads the court, again, in the exercise of its discretion and in just being prudent of both the prosecutor, the defense, and the court's time. I think it's in the interest of everyone to adjourn the trial date and grant the motion. So the court will grant the defendant's motion. Mr. Jockins, if you can submit an order either with a stipulation as to form from the prosecutor under the 7-day rule, granting the motion and staying the case pending a ruling from the Court of Appeals on your application. Can you provide that, please?
Yes, Your Honor, I will do that forthwith.
Okay, and then the court will take down the current trial dates in this case. And then once the court receives a ruling from the Court of Appeals, we'll set it for another status conference following that. Mr. Roll, anything further for the record?
Yes, Judge, for the record, with all due respect, how does the court allow the defendant to violate the court rules and not filing the motion and even having it properly before the court?
I mean, again, if I'm gonna deny it on procedural grounds, I don't think that's really gonna get us anywhere.
I don't disagree with that. However, because it was not filed with pursuant to the court rule, our office wasn't able to respond to it. I have a brief ready to go. It's the same brief I already did in Matthew for these same grounds, which is why I indicated on the record, I anticipate a decision very shortly coming from the Court of Appeals, returning it back to the court where it belongs.
And I guess that would be a basis for an appeal of my ruling here today, if you wanted to do that.
And again, it would result in the same matters, and so that would be a frivolous waste of our office. I would advise the court that all of our subpoenas have been out and served, and they've been served for some time. But again, I understand the court's ruling, and we'll take steps to contact our witnesses.
Okay, thank you. Mr. Jackins, anything further for the record today?
Nothing further for the record, Your Honor. I will get an order out quickly.
Okay, thank you. All parties in this case are free to disconnect at this time. Okay, we'll take a short recess, and as soon as we have Ms. Smith present, then we'll proceed with Mr. Rouse's case. Okay, we're on the record in People versus Stephen Rao. This is a couple different files up for hearing today. We have for sentencing a probation violation file 134686, and then two new files for status conference 236629 and 6630. If I could have both counsel put your
Sure, for the people.
Good afternoon, Judge. I'm Shannon Smith on behalf of Stephen Rao, who is seated to my right in court.
Okay, thank you. Ms. Smith, any objection to proceeding with the sentencing and the probation violation first?
No objection.
Mr. Fenton?
No, I was going to ask that you do so. Thank you.
Mr. Rao, if you could come up to the podium, please. And the record should reflect Mr. Rao present here in the courtroom today. Mr. Rao, did you have an opportunity to go through this probation violation sentencing report and to speak with Ms. Smith about that?
Yes, sir.
Okay. Ms. Smith, are there any corrections that need to be made to that report?
There are not, Your Honor.
Okay. Mr. Fenton, are there any corrections that need to be made on behalf of people?
I have no corrections. Thank you.
Mr. Fenton, anything for elocution as to the probation violation?
Yes, I do, Judge, and it's somewhat substantial. First of all, the recommendation, I feel, rewards him for this lengthy period of absconding. Basically, no consequences, credit for time served, which we would have brought him back on the other charges anyway. So there would be no punishment whatsoever. I'm going to ask the court for this may sound irrational or somewhat ridiculous, but I'm going to try to justify it with a lengthy amount of reasons for the maximum sentence, which in this case will be, I believe, 60 to 90 months. So the defendant wasn't gone for just 6 months or a year and 6 months or 2 years. He was gone over 9 years. He was given the benefit of drug court, which, as we all know, is a tremendous program meant to rehabilitate people. But instead, he thumbed his nose at the district court judge, at the circuit court judge, at the district court probation officer who'd been working with him, and just simply took off, never to be heard from again. To clearly the other side of the country, the continent. Without these new CSC charges, we would have probably never seen him again. So we had to extradite him back on those. So he's gone for almost 10 years. He didn't come back voluntarily, he was extradited back. He violated not only his probation, but the drug court rules, and like I say, absconded. He denies that he ran to avoid the new charges, which makes it even more egregious, because that might be understandable. He just says so he had an argument with his girlfriend and basically wanted to get the heck out of Dodge. Well, that's even more of a thumb in the nose of this court. So for no good reason whatsoever, he's been on abscond status for almost 10 years. Of course, the facts of the case, he's driving around intoxicated with a basically loaded gun. The report doesn't say whether the two guns were actually loaded, but there was clearly ammunition. He backs into another car and then he flees as well. So he flees in this case on the underlying set of facts, and then he flees from drug court probation. And then there's, in the PSI, there's grounds to show that he also previously failed to appear on his prior felony probation and ran, and then was returned to jail on a bench warrant, and then subsequently failed to appear again and was discharged without improvement. So nothing that this court has done rehabilitatively has worked. And I don't believe that a 6-month jail sentence, essentially, with credit for 6 months served, even begins to approximate what he's done here and what he's done since his original sentence. And lastly, I know you can't use this 100%, but you can take judicial notice of the fact that he's been bound over on 20+ counts of sex crimes across the gamut that are listed in the other file. There was an actual live preliminary exam where 3 to 4 witnesses testified about things that he's done to them, to young children. Then he's living in California at the time of his arrest with a new woman with young children. The facts that were adduced not only in the affidavits, but also at the preliminary exam that led to the bind over, clearly show that he's a very dangerous person to young children.
as all the charges in the other two files reflect. I think he's a serious danger to society, and with his history and lengthy history of failures to appear in bench warrants on this case and others, I would submit to the court that if Lockridge is to have any meaning whatsoever, that the guidelines are merely advisory and not mandatory. This case would be a perfect example to apply that principle, as well as Steenhouse. It was later decided. Not to mention the fact that there's lengthy case law that says guidelines don't apply to probation violations in any event. So for all of those reasons, I would ask the court to sentence him to the maximum and sentence him to prison.
Okay, thank you. Mr. Fenton, just so that we're clear for the record, understanding your argument with regard to the guidelines being advisory. The guidelines were originally, I believe, 0 to 13. Is that correct?
The guidelines that I have are, yes, 0 to 13.
Okay. And you're asking the court to impose what sentence?
60 to 90 months, which would be the maximum under law.
Okay. Thank you. Ms. Smith.
Thank you. Your Honor, the prosecution clearly noted that their request was extreme and provided justifications for it, but those are not legal justifications that would warrant the court giving the highest sentence ever. Mr. Rao is going to face his day in court for the sexual assault charges that are pending. Those are not charges this court can hold against him when he's presumed innocent. He is guilty of absconding the drug court. There's no doubt about that. Mr. Rao right now is 34 years old. When he was 24 years old, he was a stupid idiot. There's no doubt. He got in a fight with his girlfriend, fled the state, and quite frankly, didn't realize that this would ever catch up to him, was immature, made a horrible, terrible decision, did not realize this was following him around. He actually got his life together. He ended up going to 2 different rehab programs. He became completely sober. He got a full-time job, began working full-time, got married, is supporting a wife and 3 stepchildren, ends up having a baby of his own who is now 3 years old. Mr. Rao has been drug and alcohol free for the last several years, actually had a family, employment, everything going for him. He was not aware there was a warrant outstanding for his arrest from the drug court file that he would even need to consider turning himself in for. And when he was caught in Wisconsin, it was quite a surprise to him and his family who are in the courtroom and remain supportive of Mr. Rao. We would ask the court to please follow the sentencing recommendation by probation. Mr. Rao has quite a bit moving forward in terms of his other criminal case. There's no doubt he's going to be incarcerated longer at this point in time to get to trial on that matter. And I know we'll do the status conference regarding that matter when we're done with this. But I'd ask the court to follow the recommendation by probation and not hold all these extra things Mr. Fenton suggests holding against the defendant when that's not really what the law is for. The original guidelines were 0 to 13 months. Mr. Rao really messed up by failing to finish the drug court program, but at the same time, he wasn't facing 90 months at the time of sentencing on the offense for this case. And Your Honor, that's all. I've instructed my client also to not make a statement at today's hearing, only because he does have the criminal sexual conduct case coming up. And right now, obviously, that case is far more serious, and I don't want him making statements at this point.
All right. And I mean, in any case, it's totally up to him if he wants to allocate or not. So, number one, you know, in preparing for the sentencing hearing, I didn't really, and not that either party is required to submit anything in writing prior to this, but I certainly wasn't anticipating this kind of request from the prosecutor's office. And there's frankly, very minimal information contained, and this isn't a slight on the Department of Corrections at all either. I think they prepared this in a normal course, but there's not a whole lot of information about what both lawyers said here on the record in terms of Mr. Rao's circumstances since 2013. And I think, given the request from the prosecutor, which may be appropriate up to the maximum 10 or 2/3, may be appropriate to do time served as requested by the defense. Something in the middle of there may be appropriate. But given the prosecutor's position here, I do not have the kind of information that I would need to make the proper record to justify whatever sentence it is that I'm going to impose. So what I'm going to do is reset this for a sentencing hearing. I'm going to ask both counsel 7 days prior to that hearing to submit a sentencing memorandum to the court in writing. And that way I'll be able to, I think, be on a better basis to properly articulate the sentence for purposes of appellate review, whether that's on behalf of the prosecution or the defense. So that's how we'll proceed. The court will set that date and notify the parties of that date. And then if you could just, again, submit those memoranda prior to that 7 days.
That's no problem, Your Honor. The only thing I need to make the court aware of, I know the court's already aware, I start the big trial in Oakland County on January 23rd, and I'm going to be tied up with that for 3 weeks. I would just ask that the court work with me to give me a date after that so I can make sure I'm here for Mr. Rao's sentencing. Like we already know, he's not going to be going anywhere anyway. So further days of incarceration are obviously not prejudicing my client in any way.
Mr.
Objection.
Okay. Okay, we can certainly accommodate that.
I appreciate it. Thank you.
And then in terms of the status conference on the other 2 files, Ms. Smith, from your side of things, where are you at?
Sure. So, Your Honor, on December 27th, we actually received supplemental discovery that included a police report, which requires me to file a motion in front of the court, a motion in limine. I already have an objection drafted to the 768.278 witnesses, and I already have an objection drafted to the 803A notice. But now I know I have to file one more motion or one more objection. So I'm wondering if the court can give me some time to file that, and if we can set up a hearing with Mr. Fenton on those. It'll essentially be 3 motions.
Okay. How much time do you want the court to set aside before scheduling those?
I would ask if we could have just a month to get those 3 finalized and filed.
Mr. Fenton, any objection to that?
No objection. What I would ask though, I don't know how long the defendant's been incarcerated, but I would ask for a waiver on the record of any right to a speedy trial within 6 months, because we might be approaching that with credit since his extradition arrest.
Your Honor, I don't think that's a bad idea, and I would advise my client to waive any time frame so that we can get this case done correctly.
Okay. Can you make those inquiries of him on the record?
Sure. Mr. Rao, you have a right to a speedy trial in Michigan. Do you understand that?
Yes.
And in this case, there are some complications, some different things. I need to file some things on your behalf to properly represent you. Are you agreeable to this court giving us more time to do those things?
Yes.
Okay, and do you understand that it will make your case take longer, but I'm asking you that I need the time to be able to do the right things?
Yes.
Okay, is the court satisfied, or is there?
I would just ask one additional question.
Sure.
That any right that he has to have a trial within 6 months due to his incarceration for statute and court rule would be waived.
Yeah, I thought that was what I was covering. But do you understand that you will not have a trial within 6 months, although you are incarcerated?
Yes.
Are you willing to waive that right, Mr. Rao?
Yes, sir.
All right, thank you. Okay, so Ms. Smith, we'll set 30 days to get those filed, and then contact my office to schedule hearing dates for those. If you can, when you're doing that, let my assistant know how much time you think we would need so that she could probably set it on a date other than a regular motion day like this.
Okay, perfect.
Okay. And then I'm not going to set any further dates. I'd like to get those issues out of the way, and then we could get the matter docketed.
That works.
Thank you.
Thank
Mr.
you.
Fenton, any other dates that we can address from your side?
No, in fact, Judge, if you want to just adjourn this sentencing until the disposition of the CSC charges, that's fine by me too. Because then you'll have clearly more information on which to sentence him on if you will have heard the facts.
I'm not sure that much of that information is relevant for the drug sentencing, so I would object to that, but I have no problem with putting the sentencing off. I'm just thinking it's not necessary to hold it in abeyance until the end of all the cases.
Yeah, I agree. So the court's just going to schedule the sentencing on the probation violation again, with recognition of your schedule, Ms. Smith.
Thank you.
I think it's appropriate to get that resolved and then move on with the other two files.
Thank you.
Okay.
Did you need to cover how many trial days and things like that? Because
Not yet. No.
So we're gonna have another status conference down the road.
Correct, because I think a lot of that's going to depend on how all these issues work themselves out. So
Okay, great.
Yeah. Okay.
Thank you, Judge.
All right. Thank you.
All right, thank you. Bye. Yeah.
Mr. Frago, are you ready with your client?
Yes, we are.
Okay. Go on the record in People versus Spencer Townsend. This is case number 236642. The record should reflect Mr. Townsend's present here in court today. If I could have both counsel for your appearances on.
the record time, I go on behalf of the people.
Patrick Craig, on behalf of the defendant, Your Honor. If I may approach, Your Honor, I do have a letter from Second Chance Counseling I'd like to share.
Yes, please.
It has also been given to the prosecutor earlier.
Okay, thank you.
And we confirm that we already received copies.
Mr. Cragel, did you want this attached to the PSI?
Yes, please, if the court is.
Okay, court will attach that to the PSI. Mr. Townsend, have you had an adequate opportunity to go through the pre-sentence report and to speak to Mr. Cragel about that?
Yes, Your Honor.
Mr. Cragel, are there any additions, deletions, or corrections other than that last addition?
Just one slight correction, Your Honor, on page 1 of the pre-sentence investigation report. It indicates he's separated, but he's actually single.
Can you point to me where that is generally on the page?
Under personal history, to the right, it says Mertz status. CFJ 145, page 1.
Okay, got it. All right, court will order that correction. Any other changes?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections to the body of the report or challenges as to scoring guidelines. Thank you.
Excuse me, are there any victims that wish to address the court today?
No, Judge.
Anything on behalf of the people for allocution?
Judge, obviously, we're here with a slightly different circumstance than we had with Mr. Demacia. That being said, though, the same circumstance also applies that although individuals who choose to review these type of materials may not be making it themselves, they do create a market for individuals, thus increasing dangers to children exponentially. There's a recommendation here, and these are the defendant's first 2 felonies, which is also different than Mr. Bassett as well. That I do believe some jail time is appropriate, and there is a recommendation for it in the final probation report, and I'd ask that be followed.
Thank you, Mr. Cragel.
Yes, Your Honor. The defendant stands before the court as someone who, in many respects, is very squared away, very wholesome. He was raised in a Christian family and remains there to this day. He's got strong support from his father and mother who are present here today. And long ago, when he was 15, this hook got in him regarding pornography. He tried to work his way out of it, like he's done in many situations throughout high school as an athlete in 2 different sports. He thought he could handle it on his own. He backslid and he went deeper. He started messing into the CSAM and was arrested. But since that time, he has enrolled in the counseling, which addresses, and he will acknowledge, as the report shows, he acknowledges that he has an addiction to pornography at every level. which is something many offenders in this type of case are not willing to do. He's not justifying what he did. He's scared of the consequences, certainly, but he's digging in and trying to rehabilitate his life with the support of his family and his employer. And it's important to note that, you know, someone who's on probation, we want the support of the community or the observation, the participation of the community. This young man has it. He works at a local business. His mother works at the same business, who will be keeping an eye on him. His father is involved in his life on a day-to-day basis. He was deeply involved in athletics at his high school. So he's someone who has got a pattern. He's got an opportunity to rehabilitate and a motivation to rehabilitate. For those reasons, Your Honor, I would ask the court to give him a local sentence, follow the recommendation of the Department of Corrections, and allow him to have a probationary sentence with a brief jail term. On another note, I would note that the report said he's PA 511 qualified, so we would ask the court to allow him to have work release so he can continue in his employment. It's my understanding his mother will be picking him up and bringing him right back to the jail if in fact that's granted. Thank you.
All right, thank you. Mr. Townsend, anything that you wanted to say?
Yes, I brought a statement with me.
Okay.
So when I had initially viewed the child sexually abusive material, I hadn't given much thought to it, and that has changed drastically. When I read the description of what I'm guilty of, my stomach turns at the fact that it even exists. I'm deeply ashamed of those same very words that describe the heinous acts I viewed, knowing that I in fact had the possession of them at such time. I'm disgusted at my actions in viewing such content, and I take the blame for those actions, and I feel for the victims that were depicted in the material I possessed. And I can't begin to understand the damage the victims went through, both physically as well as mentally, and the constant remembrance of what they had experienced in their past and how afraid and violated that they had felt in that moment and probably still feel. I've spent much time thinking of how it would affect me if I were one of the victims. It would crush my spirits and destroy my trust in people. I also think of how I would react if I had a close friend, relative, or sibling go through the trauma these young girls had went through, and it makes me feel ill, sad, and revolted at such crimes. The reality of having to register on the sex offenders list for the next 15 years of my life, as well as multiple years of probation, has opened my eyes to the severity of living a life of crime, and it's not a path I wish to follow. And within the past few months of the process, I've also independently reached out for help through counseling every week to not only understand the reason this has come to be, but to also ensure that it is not a reoccurring issue. It has brought to light a variety of perspectives and knowledge I hadn't understood prior, and it is positively affecting my daily life. I currently am doing a daily journal, which I brought with me today, to learn of acceptance and commitment therapy and helping me to understand my thoughts and emotions, and I'm eager to continue with my appointments. Thank you.
All right, thank you. I did read through the report. I'm familiar with what happened in this particular case. There's also a lot of information in that report about you and your circumstances and background. And I take all of that into account along with what the lawyers have had to say here and yourself as well. You know, just by pure coincidence, I had a similar case earlier today. Very similar charges, as Mr. Roll indicated, much different circumstances. But I'm going to reference that throughout what I'm going to say to you so that you can see where this goes if you don't get a hold of this issue sooner rather than later. Number one, I'm going to tell you what I told the other individual, and that is this is one of the most serious crimes that this court deals with. And that's because it involves children. Children are defenseless. They rely on adults and older individuals to make good decisions for them, to care for them, to protect them from this kind of thing. And the children that are involved in this have been violated, and they have been let down by the adults around them in terms of that trust. And the people that consume this stuff and look at it, while they're not producing it, they're not involved in the production of it. By viewing it and being consumers of it, they're helping it to continue because they're providing a motivation and a reason for people who are making it to continue making. And so the consumers are actively involved in the victimization, in my view, to the same degree as the people who are making it, and are no less culpable. So the court has a very strong interest in punishing and deterring both people who are making it and those who are consuming it. I do think that there are significant differences between this case and that previous case. Number one, that other individual had an opportunity, the same kind of opportunity that you're going to get today, to get some treatment, to get counseling, to move on from that. That individual chose not to do that. They chose to violate their probation and to find ways around the court order to continue viewing this. And that person got sentenced to almost 7 years in prison today. And I'm telling you that so that you understand you're going to get an opportunity through a lengthy term of probation and a short term of jail time to get treatment, to get counseling, to do the kind of things that you need to do to move on from this. And if you don't, there's going to be very, very little room for error on your part. And if you continue to engage in this, if you try to find ways around your probation to continue to do this kind of material, and you're caught, you're found guilty, chances are it's going to be prison, and it's going to be a serious length of prison. And I don't think you want that with these kind of charges. So I want you to understand that this is a very slippery slope, and it can go downhill really quickly for you if you don't take advantage of the opportunity that you're going to have. And I also want you to understand that there's going to be very little room for error for you while you're on probation. All that being said, you know, I think I listened very carefully to what you had to say here today, and I think you're looking at this from the right standpoint. And the things that you said today on the record are much different than what that other individual said. The other individual tried to equivocate, try to draw lines, try to say, well, it really wasn't that bad because of X, Y, and Z. What I'm hearing from you is acknowledging that it was wrongful. What I'm hearing from you is you recognize the effect that this has on people involved, children involved, and that you don't want to be part of that victimization pattern. And I hope that you're sincere in that. You appear to be sincere to me here today. And I hope that you're going to be on probation for quite a bit of time. And so time's going to tell whether or not you're sincere. But I hope that you are, and at least at this point, you're expressing the kind of things that I think are going to help you move on from this if you keep those things in mind. I do think that the recommendation is appropriate given your case and given your circumstances, and the court is going to follow that recommendation. Again, I think a long term of probation is appropriate to make sure that you are monitored and that you don't engage in this kind of activity. I think a short term of jail, particularly given your lack of any kind of prior history and your age, is important, because I think that's going to impress upon you what it's like to be incarcerated and hopefully provide added motivation to you. I don't think a lot of time at your age is necessary to do that. I think a short term is going to make a big impression. So I think the recommended jail time is also appropriate. I'm not going to allow you to be released during that time. I think serving the 30 days straight up in jail is important for you to have that experience. So the court is going to place you on probation for a period of 5 years. The court is going to adopt as the conditions of the probation all the terms and conditions that are listed in this report. And that includes all the provisions regarding limitations of your ability to be within school zones, to be around younger folks, minors, possession of any kind of sexually stimulating materials. The court's adopting all of those as terms of probation. So it's going to be really important for you going forward to talk to your probation agent, make sure that you fully understand all those limitations so that you don't run the risk of violating any of those. The court is going to order that you serve 30 days in the Otsego County Jail. You have credit for 1 day served. The court is going to order a crime victims assessment in the amount of $130. supervision fee of $30 per month while you're on probation, court costs of $325, DNA testing fee of $60, and $136 state cost. You do have the ability to seek an appeal of this sentence, and Mr. Fragel, if you could just have your client challenge receipt of those appellate rights, please. All right, Mr. Fragel has Mr. Townsend.
Yes, he has.
Mr. Roller, anything further on this file today?
No, Your Honor, thank you.
Mr. Fragel. Anything further?
Nothing further.
Mr. Townsend, you are remanded to the custody of the county at this time.
Set this up now for right now.
All right, the next matter is People versus Patricia Hampshire, case number 226342.
For the record, Judge, my role as the people.
Steve, can you just see if there's anybody in the hallway, please?
Judge, if you want to call.
Nobody out here.
Let's call the case. I have information of the court. I don't believe she's going to be.
Okay, this is case 226342, People versus Hampshire. The record should reflect this hearing was set for 4 o'clock. It's now 4:05. Ms. Hampshire is not present in the courthouse and has not attempted to connect by Zoom. Mr. Rolla.
Thank you, Judge. According to our file notes, this is the second time Ms. Hampshire's failed to appear. Further, she now apparently has an address of 303 South Apple Street, Pearsall, Texas, 780612301. I doubt very much she's going to be coming here from Texas unless she's brought here from Texas.
All right, and I have in the file bench warrant that was signed by the court in July of this year. So I believe that's still active. So the court is simply going to adjourn today's hearing and have this matter scheduled once, if ever, Ms. Hampshire's arrested and brought before the court.
Very good, Judge.
And then the last file for the day, People versus Brian Nelson, case number 226252. Again, this matter was set for hearing at 4 o'clock. It's now 4:06. Mr. Nelson is not present here. Mr. Rolla, anything on this file today?
He failed to appear previously on March 15, 2022, and his whereabouts have been unknown, I believe, since.
Thank you. And the record reflects there is an active bench warrant for Mr. Nelson. So as with Ms. Hampshire, the court will simply set this matter out until Mr. Nelson is apprehended and brought before the court. Anything else on the record on that file?
No, Judge.
All right, thank you. That concludes our docket for the day. The court will be in recess until 9 a.m. tomorrow.